I've completed going through with you the documents that are going to be filed electronically with your bankruptcy petition, but I want to go through some other documents that are going to come up that same day. If you followed through with me, you now know that I have filed your petition electronically. You and I have signed your petition, but that's not the petition that I actually send to the bankruptcy court. I send an electronic copy. Well, that's where this document is. You recognize, I'm sure, that the judge is an officer of the court and the trustee is an officer of the court. Well, we debtor attorneys, we're also officers of the court. So they will accept and do accept my representation that I have your petition that you and I have signed. So they're never going to see that unless something comes up or that's in question. But what we do provide to them, you and I, on the date that we sign your petition, you and I are going to fill this form out, Declaration Re Electronic Filing. And essentially, I want you to read it, of course, but essentially what this is saying, hey, I'm the debtor or debtors, and we are filing our petition electronically, and that meets our approval and our request. So you and your wife, if it's a joint filing, you'll both sign it. I sign it, and then I put it in an envelope and mail it to the Federal District Bankruptcy Court in Kansas City, and they keep that on file. Now, the next form is real important, and I want you to know about this form. Within, gosh, I don't know, 30 seconds after filing your bankruptcy petition electronically, the bankruptcy court computer is going to assign a case number to your filing. It's that quick. Well, I can then download this from the federal court website. It will list your case number, your name, your alias names, your address, the last 4 digits of your Social Security number, and it will also put my name on it as your attorney. Well, that's proof from the bankruptcy court that you and I have filed your bankruptcy petition. Well, what am I going to do with that? Well, let's say that you've got a pending foreclosure sale on your residence. Well, a couple of seconds after I get this document, I'm going to fax a letter to the attorneys and the trustees that want to foreclose on your home, letting them know that we have filed bankruptcy and that they've got to stop that foreclosure. It isn't up to them whether they agree or disagree with us. Under federal law, once I give that notice to them, anything they do after that is a legal nullity. It doesn't count. Well, they're not going to do that because they would be in violation of the bankruptcy laws and they'd be subject to damages. So, you stop and think about how powerful bankruptcy is. You and I have filed the bankruptcy. There's been no judge involved in that. And yet we have the power by filing it to stop a foreclosure sale. So it's extremely powerful law. Also, let's say that your wages are being garnished. Well, I'm going to send a cover letter and a copy of this document to the attorney that's garnishing your wages. And I'll say in the cover letter, hey, I'm Jim Maroney, I'm the debtor's attorney. I've attached to this letter a copy of the court's notice of filing. I want you to immediately contact the debtor's employer and stop that garnishment. Well, he's going to do that because he doesn't want to get in trouble with the bankruptcy court either. Once you and I filed this, there's a section in the bankruptcy code called 11, or captioned USC, United States Code, Section 362. Well, that's an automatic injunction. All creditor activity, foreclosures, bank account attachments, garnishments, all of that stops by the mere fact of you and I filing a bankruptcy petition. So you have to ponder a little bit to realize how powerful the bankruptcy code is. Well, I use that. That's what we do. That we stop all the imminent threats to you and your assets. The next document that I want to show you, that notice above that I download from the court, I send that to all the creditors that are garnishing and foreclosing. I also send it to every one of the lawsuits where you've been sued by a creditor. I let the state court judge know in every one of your collection actions that we have filed a bankruptcy. Well, that stops the judge or anybody else in that state court action from taking any collection action against you. So if you've got some pending court dates for collection lawsuits and all, you're not going to have to go to any of those, because once I file that notice with the court, that lawsuit's dead in the water. So don't be worrying about it. That's, again, the power of the bankruptcy code. Well, here's the notice. I send the notice to all your courts, state courts where you've been sued, and emminent foreclosures, bank account attachments, and garnishments. But all the rest of your creditors are going to get this notice, and it will come from the bankruptcy court itself. And they get this letter out within a day or so after the bankruptcy petition is filed. There's a lot of important information on this, and I want to go through it with you. You will receive a copy of this, just the same as all your creditors. I will receive a copy by U.S. mail, but even more helpful to me, the day they send it out, they'll also send me a copy of it electronically. So there's a lot of information on here that you and I want to know. When your creditor gets this, again, every creditor or whoever we put on the mailing matrix is going to get this document, but it will list your name and your address and all your aliases. It'll list your case number, the last 4 digits of your, and if it's a joint filing, your wife's social security numbers. It doesn't list the full social security number, just the last 4 digits. It'll list my name over here, an attorney for debtor, and address. In fact, it goes further. It'll have name, address, and telephone number. Now, for the very first time, you and I will find out who the trustee is for your case. Now, I'd mentioned that in Chapter 7 cases, you and I will have a contractor who works for the Department of Justice. That person may or may not be an attorney. Well, part of the $299 filing fee that you paid for a Chapter 7, $60 of that will be paid to whomever is appointed the trustee in your case. Now, if they can grab some assets from you or for secured creditors or something, they're going to make a lot more than $60. So don't be feeling sorry for the contract trustee. But we know who he is. Well, why do I care about that? Well, every one of these contract trustees has a different set of questions that you're going to have to answer and bring with you to the 341 meeting. Well, once I know that, then I know what questions the trustee is going to ask you, and you and I will prepare all of that so we have it ready. A lot of these trustees, I shouldn't say a lot, but some of the trustees have peculiarities about them, and I'm aware of those, and we'll get you ready for the 341 meeting. The meeting of creditors, it'll give the date and time as to when your 341 meeting is going to be held. Your presumption of abuse, it tells everybody, hey, I haven't done anything wrong. Deadline to object. This is a real important date that will be on there. When you look at this date of deadlines, date to object to discharge, in a normal bankruptcy, your order of discharge is going to be granted within a day or two after that particular date. So that's important for you to understand. There's some more I want to show you on this, so unfortunately we're going to have to go to another video.